Friends, I just pressed the Let's Go Live button, which means we've got to wait for the stream to fire up all across the fruited plain of the internet. Before we go ahead and get started, we got to make sure the tubes are working before we start rambling off here. And it looks like they are connected, which is tremendous news. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Govt. I am a criminal defense attorney, and today we're talking about Donald Trump and his privilege, which happens to be under attack. And this is a pretty spicy one that I'm excited to share with you today because, man, if this goes Jack Smith's way, he might have access to all of Trump's attorney-client privileged documents, okay? All the communications between Trump and his lawyers might be fair game. And let's not forget where we are. We're in Judge Chutkan's courtroom. And so anything can happen here. And this is kind of a wild thing that's happened, is the government is now asking Judge Chutkan to force Donald Trump, or to require Donald Trump to declare about whether or not he's going to be using this affirmative defense, which is basically blaming his lawyers. Okay, so if Trump comes out and says that I was only acting on advice of counsel back during January 6th or in my contestations of the 2020 election, then the government is saying, oh, well, if you're relying on your lawyers, then Judge, we should be allowed to see all your communications with your lawyers. And so all of that should be opened up. Now, this is something that is not common in other places around this country, as we're going to see in this very motion. Jack Smith's prosecutors, they go to great lengths to distinguish what's happening in D.C. from other cases. They're saying, in other cases, this wouldn't happen, but Trump's case is unique. And so, Your Honor, you should make Trump decide about this affirmative defense called advice of counsel and make him decide now. And if he, if this goes against Donald Trump, we have a whole Pandora's box that gets opened up. So we'll take a look at that filing. We'll also see what the actual order looks like. This is a proposed order from Jack Smith and the prosecutors to the judge saying, Your Honor, just basically sign off on this, and then that will establish the new rules. So we'll go through that. And we also see that in Florida, of course, we'll spend a lot of today talking about D.C., but in Florida, there was actually a delay in the case. And so we're postponing that one a little bit. Not much to unpack there, but I did want to make sure we were apprised of all of that. And so that will be what we attend to in our first segment. But that's us only getting started. And we've got more Jack Smith and special counsel business to attend to. Then in our next segment, Jack Smith also submitted a motion for what he's calling a fair jury. All right. Now, he's wanting fair protections to make sure that they get a, quote, fair jury. And we're asking ourselves, this is a little bit nuts, because we know that Jack Smith is prosecuting this case out of the Washington, D.C. circuit. And we know that the Washington, D.C. jurisdiction in and of itself is basically 95% Democrat, give or take. And so what does fair mean exactly? And to whom is this standard applying? We'll go through it and see what's inside. That motion was drafted by Molly Gaston. And then we'll wrap it up with some Hunter Biden updates because, boy, oh boy, we knew this was coming. We've talked a lot about this, okay? I think the day that the plea deal actually fell apart, we were saying, oh my goodness, they're going to claim that Hunter has immunity from all future prosecutions. And by golly, we are here, and they're doing it. Now, we've already seen hints about this, but Hunter's lawyer, as we know, his name is Abbe Lowell, or Abbe, as Garrett Ziegler corrected us on about that. Apparently, he submitted a motion requesting that, well, he's still standing by the immunity provision. He's saying that Hunter Biden and the government executed a deal. It's a done deal. Even though the plea deal fell apart, the other half of the deal, which involved the diversion agreement, that was still in effect, and saying that that is immunizing Hunter at this very moment. We'll also check in with what's happening with the Biden crime family because there's more updates. We know that America First Legal has submitted a lawsuit against Biden and really the National Archives. They want to know about these emails. And pursuant to this lawsuit, we now have information that there were 25,000 plus emails, over 25,000 emails that went from places like Rosemont, Seneca, from Hunter Biden himself, 4,000, 1,700 emails from VP President Biden's office to Jim Biden, 3,700 emails to Jim Biden's Lion Hall group. So it wasn't just talking about the weather. There's over 29,000 emails between Hunter Biden and the Biden crime family and all of their associates and the vice president's office. So talk about no evidence. We'll see what that's all about. And there's also been a question about where has Joe Biden been? Anybody had eyes on him? Well, it turns out he may have been being interviewed by Robert Hurr, the special counsel, who is investigating his own classified documents saga. And so, my friends, as you can see, we have a lot to get to today, and I'm grateful that you are joining us on this beautiful Tuesday. This morning, we had an amazing members-only stream. We talked about what's going on in the brewing war over there in the Middle East. We got some highlights and updates on the speaker's race. Of course, Kevin McCarthy's kind of throwing his hat back in the ring. And we also talked about this new report from the Judiciary Committee that was saying that about 99% of the illegal aliens, the illegal immigrants coming across the border, are not being deported, not being detained, right? And they're actually going through the process, but it's just basically for show. It's all just fake. They're all being processed, and so we'll be working on that video for the main channel here shortly. But we appreciate our members. We're so grateful for our members. Had a lot of intelligent people sharing some pretty intelligent ideas at Vid Summit, and so I've got some ideas on how to do some more fun stuff to make some deeper connections in our community. And so we're grateful to our members. If you want to join as a member, come and join us. Watchingthewatchers.locals.com is a great place to connect with us. You can also grab access to our members-only private Telegram group. We do members-only streams in the morning. We do Saturday shows. We've got a lot of other fun stuff cooking. So come check us out, watchingthewatchers.locals.com. And really, it is the best way to support the work that we do here. The more support we get from memberships, the less I have to worry about Google monetization and all the other things. And so we're grateful to you for becoming a member to keep this show on the road. And you can also get some other good stuff at robertgovea.com. You can check out our show reports. All the video stuff that we do gets translated and posted on the website. And so you can check that out if you're short on time. You don't have time to read everything. You just want to see what the news looks like. Check it out, robertgovea.com, and get all the reports over there. We also want to say this week, we're sending all of our extra love, and I appreciate anything that you've got to send over to Eric's house. This week is our big week, so we've got our annual fundraiser this Saturday. Yours truly is going to be emceeing the whole thing. It's about a 4-hour presentation. We've done it several years. It's a lot of fun, a lot of good stuff. But Eric's house is dedicated to helping people who've lost someone that they love due to suicide, overdose, or tragic death, right? Drugs and suicide are just wrecking our entire country right now. And so when that happens, when somebody loses somebody, oftentimes there's no support for the family and the people they leave behind. And that's what Eric's house is all about, helping and hoping and healing for people that have lost somebody to get things back on track. And so if you go to watchersupport.com or click the link in the chat, it'll take you over to this website, and you can make a dono for your boy's page right here. Or you can, you can support my mom, or you can support my dad, Greg, or you can support anybody else of these amazing people. But of course, we're trying to raise some money, and we're going to be doing it all this week, and we'll be saying shout outs to everybody who is making those donos, and we already see them coming in. Jesser, Bob, Tanya K, you guys are awesome, and we'll make sure to send our love here a little bit later. But so ericshouse.org or watchersupport.com, you can type that into your browser, and it should take you right over there. Now, let's get into it, my friends, because we've got some legal business to attend to on the lovely day. And let's get right to it. Special counsel Jack Smith now trying to breach Donald Trump's attorney-client privilege. He's saying Donald Trump is going to be using an affirmative defense. He's going to be saying that Trump is relying on his lawyers to justify his behavior in 2020, to justify the insurrection and all of that. So Jack Smith says, okay, if Trump's going to be saying, I was just following my lawyer's advice, then Jack Smith should be able to get to see what that advice was. These are communications that are ordinarily protected, but if Jack Smith can breach that, that's a pretty big deal. And Trump, at this moment, is not even officially using this affirmative defense, okay? Donald Trump has not filed a notice in the court of law saying that I am going to be invoking, that I was relying on my advice of counsel. Never come up. But he's made other statements on Truth and elsewhere. And so Jack Smith is saying, well, we think he's going to be using this defense. And so we're preemptively trying to breach his attorney-client privilege right now. And I know this might sound crazy, like you're like, what, Rob, what are we in, like bizarro world? I thought this was the United States and the government couldn't just ask the judge to shatter the relationship between the defendant and his lawyers on their own, right? The government just asks for it. And we're in Judge Chutkan's courtroom, and so we don't know where this could possibly go. Judge Chutkan has already said Trump really doesn't even need to read the evidence against him, in this case, the discovery, because it is so monumental, the amount of it is so monstrous that there's just not enough time for all of Trump's lawyers to read all of it. And the judge said, well, we don't really care about that. That's your problem, not mine. So now, if the judge finds against Trump, what are we going to see? Are they going to go after all of his attorney's communications and see what's inside there? Because why not? They're already prosecuting him and breaking 234 years of American tradition to do it. So why not? What else? Well, we'll look at what Jack Smith and these so-called prosecutors have submitted, and we'll also see what the proposed order looks like, because this is what they want the judge to sign off on that would give them all this extra power to go look at Trump's private communications with his lawyers. So here's the motion, and it is a 14-pager. And you see, it is the United States of America versus Donald Trump. And unlike another motion that we'll read in another segment, this one is written by Thomas Wyndham. We've been used to seeing Molly Gaston on some of these cases, but this one's a little bit more technical. Molly's kind of the highlighter person. And so they put Thomas Wyndham on this one. And he's obviously with Jack Smith's office, a little bit more senior attorney, I would imagine. And here is what he argues. He says, Your Honor, Judge Chutkan, the same judge who has refused to recuse herself despite making insane statements that, in my opinion, obviously show her bias, she has refused to allow Trump to get any time to actually listen to the evidence or to read the evidence. And we talked about how it would be 8 to 10 Washington monuments. And so now we're going to throw another opportunity for her in the case to really stick it to Trump by shattering his attorney-client privilege. Let's see what the government prosecutors are arguing to the judge. Your Honor, Judge Chutkan, this is Jack Smith's opposed motion, which means Trump is already opposing this, obviously. And they say that we want formal pretrial notice of Trump's intent to rely on advice of counsel defense. So we want formal notice. Okay, we want to put this in writing. They say, Judge, Donald Trump has provided public notice. Okay, so Trump is saying stuff out there in public. They want him to shut up too. They want to gag him for that purpose as well. But he has said this in public, not in court, that he intends to rely on an advice of counsel defense at trial. And they're going to walk us through some of Trump's statements, and we'll see. Now, when a defendant, in this case like Trump, when he invokes such a defense in court, he waives attorney-client privilege for all communications concerning that defense. And the government is entitled to additional discovery and may conduct further investigation, both of which may require further litigation and briefing. So, Judge, because Trump said something in public on an interview or on tweets or whatever, we think that he's going to do it, and so you better give us the right to go in and just investigate all of those communications because we said so. And so to prevent this, and this is going to Judge Chutkan, remember, to prevent disruption of the pretrial schedule and the delay of the trial, the court should exercise its inherent authority to require Trump to produce notice in court of his intent to assert that defense by December 18th. And through counsel, Trump obviously opposes this motion. And why are we going to tell you about our defense? You want to know what we're going to argue? Would you like our defense theory as well, and all of our work product? So here's the background. This is Jack Smith and his prosecutors writing. They say, during the course of the government's investigation, at least 25 witnesses withheld information, communication, and documents based on assertions of attorney-client privilege under circumstances where the privilege holder appears to be Trump or his presidential campaign. So they're saying a bunch of people that we tried to get evidence about or on or get to turn on Trump, they all invoked. They said, well, we're not talking to you. So these included co-conspirators and former campaign employees, so other people who may or may not have been charged, the campaign itself, outside attorneys, and a non-attorney intermediary, and even a family member of Donald Trump. These are all people that said, I can't talk to you, attorney-client privilege. Now, in the time since the grand jury returned the indictment against Trump on August 1st, the defendant, Trump, and his counsel, his lawyers, have repeatedly and publicly announced that he intends to assert the advice of counsel as a central component of his defense at trial. Trump saying, I'm innocent, man. I was the president, okay? I was following a bunch of lawyers. And we've talked about this here before, okay? A number of other people who've been charged or alleged to have been involved as maybe unindicted co-conspirators were members of the Department of Justice. They were all lawyers, okay? Rudy's a lawyer. Sidney's a lawyer. Jenna Ellis is a lawyer. There's all sorts of other people who all got caught up in this. And so Trump, who is not a lawyer, is relying on Department of Justice officials and other legal experts with law degrees telling him that he has a valid claim here. And by the way, I agree with him. And we've talked about it. Now, you might say it may, it was a questionable maneuver, like it's never happened before. That's true. And you might say that maybe it's not in the best judgment to push it as far as Trump did. You might have those opinions or whatever. But the fact is that it wasn't illegal, and it still isn't illegal to exercise and to investigate your claims in this country. It would be like if a defendant charged with a crime was prosecuted for defending himself. So here we have them continuing. They say, on the night of August 1st, for example, Trump's lawyers told a national audience on Fox News that the defendant had, on advice of counsel, a very detailed memorandum from a constitutional expert. Footnote 1, Fox News. So some lawyer for Trump, don't know who it was. So some other person, a constitutional expert, did some research on the case. Incredible. They got outside opinion and they got some research done on their legal case. Incredible. Wow. This is what happens in the law every single day. So they have a detailed memo doing some research. Hours later, the defense counsel argued that Mr. Trump had the advice of counsel, Mr. Eastman, who was one of the most respected constitutional scholars in the United States, giving him advice and guidance. And that's true. Forgot about John Eastman too. So CNN, another interview. We have another footnote from NPR. We've got another footnote from Meet the Press, just so we don't have to go back down. The following day, defense counsel was asked on NPR to, talk a little about your legal strategy and give us a summary of your legal defense to these criminal charges. And defense counsel responded, said, well, it's not a big surprise. Trump got advice from counsel, very, very wise and learned counsel, on a variety of constitutional and legal issues, all talking about this publicly. Now, 3 days after Trump got arraigned, Jack Smith and the prosecutors say that Trump's lawyers made appearances on a circuit of Sunday news shows. They went around and hit the news shows. On NBC, defense counsel explained, they said, what Trump's being indicted for ultimately is following legal advice from John Eastman. And one thing's for certain, President Trump acted under advice of counsel when he petitioned under the First Amendment, when he petitioned Mr. Pence, and that's legally protected speech on Meet the Press. Likewise, on CBS, and these are all back from August, okay? August 1st, August 2nd, August 6th. Likewise, on CBS, and just to be clear about this, right? We have not got any discovery at this moment. We're still missing a ton of discovery. So we rewind the clock 2 months ago, and we had nothing, all right? So all of this, just in context, is very speculative. So maybe they are speculating about it. And you're allowed to do that, by the way. You don't have to communicate, or we used to be allowed to do that in America. We'll see what Judge Chutkan says. But apparently she's telling the government is asking the defense to tell them what their defense theory is so that they can go and prepare to beat it, right? So likewise, on CBS, defense counsel claimed that Trump, quote, believed a certain course of action described in the indictment was appropriate because he was following the advice of John Eastman. On CNN, defense counsel, and I still don't know who this is, I wonder who it is. On CNN, defense counsel argued that the conduct alleged in the indictment was sanctioned. In other words, Trump could do it because Trump was following the advice of his lawyer. Weeks later, Trump himself explained in a Twitter interview, probably with Tucker, that we had some lawyers, not all, but we had some lawyers that said a particular course of action described in the indictment was appropriate, right? And that's exactly right. Not all lawyers agreed with Trump. A lot of them didn't. And Trump is still allowed to pursue lawful courses of action. And at the time, Mike Pence had a ton of authority to do certain things. And we know that because they changed his authority after the fact. So on August 28th, the court entered the pretrial order to organize pretrial proceedings. They're telling the judge this. So Trump made those statements before you scheduled the deadlines here. Among other reasoned deadlines therein, the court set December 18th as the date for the parties to exchange lists of exhibits. And so the government's now going to say, we need to know about all this so that we can be properly prepared. By that date in December, the defendant will be required to identify, if he's not already done so, any exhibits that Trump is going to be using in his case, including exhibits that are supportive of this advice of counsel defense. Now, let's see if they give a little bit of background on what an affirmative defense is. I think we'll just do a quick explainer on it. So an affirmative defense is saying that, yes, I did the conduct, but I was allowed to do the conduct. So you can often think about this as like self-defense. Self-defense, maybe you're charged with assaulting somebody. You're charged with assault. Why? Well, you punched that guy in the face and you broke his nose. Oh, well, technically that's an assault because it's a physical conduct. Your hand hit his face. But you might say, I have an affirmative defense to that. I was acting in self-defense, and so that negates the criminality of the original assault. Okay, so you're admitting the conduct. You're not saying, I didn't hit the guy. You're saying, yeah, I hit him, absolutely. But it was self-defense. And so depending on your jurisdiction, it depends on how you prove that up and so on. But for our example here, they're saying, Trump is saying that, yes, I did these actions. I made the text. I made the phone calls. I said the thing, blah, blah, blah. But I was allowed to do that because I was following advice of counsel along and amongst other things that would immunize him here. So they're saying here, Trump, because he's using this affirmative defense, he's going to be required, the burden is going to shift over to him. He's going to have to make a showing of this. He's saying he relied on counsel, so he's got to put some evidence up. The defendant, Trump, will be required to introduce evidence that, one, he relied in good faith on the lawyer's advice and that his course of conduct was, in fact, legal. Okay, so he's got to, prove both of those things. And number two, he made full disclosure of all the material facts to his lawyer before receiving the advice. So his lawyer would assume some of the liability because Trump told him everything and his lawyer did the best he could and the lawyer gave him bad advice, but it's not Trump's fault. And Trump relied on it in good faith and thought he was following the law, but he ultimately wasn't. So they say if Trump satisfies, which is a pretty high burden, right? That's a lot to prove. If the defendant satisfies the burden to produce evidence that would support this defense, if they can meet that standard, the court should then instruct the jury on the defense to tell them that Trump has made this claim. He's proven up some part of this. And then the government retains the burden of proving the mens rea beyond a reasonable doubt. Okay, so we don't have to talk about, in criminal law, we talk about two things, the mens rea and the actus reus. In order for many crimes to happen, you got to have both of them. A guilty mind and a guilty act. Mens rea is a guilty mind and an actus reus is a guilty act. You put them both together. They're saying here, okay, just like in the punch case, right, the physical act happened. Trump made a certain statement or said certain things or somebody threw a certain punch, that happened. But what was the mens rea behind it? What was the thought process? Why would that person in the self-defense position believe that a reasonable belief that they were in a position where they could exercise self-defense? Why would Trump have the mindset that he could do these things? And so if Trump says, I was relying on counsel, the government doesn't have to prove anything about the underlying act, only that Trump didn't actually believe that. They just kind of got to get into his mind. But they want this to be clear. So they want Trump to figure this out now. Now, they say, in invoking the advice of counsel defense, and Trump has not officially done this yet, okay? So they're just saying Trump has done this because of his prior statements. He's not formally filed anything yet. He probably hasn't even read the discovery yet. In invoking the advice of counsel defense, he has not done it, but they're just thinking past the sale, right? They've already told the judge he's already done it. The defendant waives his attorney-client privilege on all communications concerning the defense. Wouldn't that be nice? They can just crack open the shell and open the floodgates for a defense that Trump has not even invoked yet. They've just been talking about it on cable news, which they're allowed to do. Accordingly, once the defense is invoked, which again it has not yet been, the defendant must disclose to the government, and this is really what they want. Like, could you imagine? They'll throw a party at Jack Smith's office because this is what they're going to get. All, quote, communications or evidence that Trump intends to rely on to establish the advice of counsel defense. So a lot of private convos between the attorney and Trump, and any other privileged communications that the defendant does not intend to use at trial, but are relevant to proving or undermining it, okay? So the floodgates are open. They can start demanding all of the communications between Trump, even if he's not going to use that, to undermine the very claim. And they say, accordingly, Your Honor, waiting until the eve of trial, or worse, when jeopardy attaches, for them, like for the defense, this is better, okay? For Trump's perspective, you want jeopardy to attach so that when you screw up, when the case gets screwed up, they can't bring it back again. But they want to get this all figured out before jeopardy attaches, because that's how they get an advantage. So they say, Your Honor, we can't possibly wait. Like, what happens if Trump brings this up right before trial? And he catches us off guard or something, and we don't know, and so we better know now so that we can begin combing through all of his records. So they say we better do it now, or worse, when jeopardy attaches, which, after the jury's impaneled, to raise an advice of counsel defense risks causing substantial disruption. They don't want their prosecution disrupted. That's the point, by the way, okay? The defense hides their cards until the last minute. In fact, sometimes the defense hides their cards throughout the entire trial. Call it a shiny object. You just have this shiny object you keep waving around in front of the prosecutor. They think you're talking about this the whole time, and your closing arguments like about this. Boom. So, but they don't want that. They want to know right now what Trump's arguments are, especially if it's going to give them an opportunity to go get all of the privileged communications. So it would cause substantial disruption or delay, which is what the defense intends to do, and that's right, their right to do it, particularly in this case, given the number of attorneys involved. Yeah, it's the president, hello. So they want to avoid such disruption, which, again, favors them. It's like taking the timeouts away from the other team or something, right? Because they don't want you to stop them when they're kicking their field goal. Says courts in this district and others have concluded that while the federal rules of criminal procedure do not address this defense specifically, you see what's happening here? To avoid disruption, courts in this district, now we're being very careful here, this district, where are we? We're in Washington, D.C. And others, we'll see which others, have concluded that while the official rules of criminal procedure do not address this, they don't talk about advice of counsel, they still say, Your Honor, judges retain inherent authority to order defendants to provide formal notice before trial. See that? So it's not in the rules, Your Honor. And this court, which is an aberration of justice, in my humble opinion, that's taking place in Washington, D.C., that's not the same as other courts. It's far outside of the norm. But he's writing to Chutkan saying courts have broad discretion to kind of do whatever they want. They can impose pretrial notice, and the majority of district courts have considered the question and have exercised their inherent authority sensibly when it's necessary. So they give us a bunch of examples saying other judges have done this before, Your Honor. Look at all these examples. But they do, okay, this is where they have to distinguish this, because this is not, I would guess, I haven't done independent research on this because we're just going through their motions, but I would imagine that they've got a bunch of bad case law because they're distinguishing it here. So as we saw, okay, this mechanism is not even discussed in the rules, the federal rules of criminal procedure, the big manual, the big book that everybody goes to. It's not in there. So they just say, well, Judge, just kind of make it up. Other judges have done the same. They say a number of courts in cases unlike this one, have denied the notice. Okay, so Trump wins in a number of courts. He wins, but Trump's case is different than this. So he would win if we go by their standards, but this is why his case is different than their standards. And they give us some pretty big cases. United States versus Ray, Southern District of New York. They declined to impose a notice requirement, saying that there's no consensus among the federal courts. So we say there's no good cause. Here's this one, Eastern District of Tennessee. We find that there's no good cause to compel the defendants to provide notice before trial. Yeah. What? The defense needs to explain all the theories of their defense? Another case from the Eastern District of New York, 2017, concluding here that the prosecution in the case had not established a right to pretrial notice of the defense. Here's another one, Eastern District of Kentucky, declining to require notice of the defense pretrial. It's like you have to give the playbook to the prosecutors. But we're not in Kentucky, are we? We're not in the Eastern District of New York, or we're definitely not in Tennessee. Or the Middle District of Florida. We're in Judge Chutkan's courtroom. So they say, Your Honor, look, this is why they're writing for Hurr. Backing up, they say, look, hey, by the way, this one came out of Middle District of Florida, 2008. Defendants are not obligated to put on any defense, and except for suit and enumerated defenses, which must be disclosed prior to trial, defendants are free to make that decision at trial. You can bring your case and put your case on when you walk into the courtroom. You don't have to give the prosecutors options. Here are the 3 tactics we're going to use. Try to guess which one we're starting with. So here's the government. They continue. They say those out-of-circuit cases are readily distinguishable, okay? Those are from Kentucky, Judge. We're in Washington, D.C. We're better than everyone else. We're better than Tennessee and Florida. So we can distinguish those cases. And the factors that animate their contrary rulings are not present here, okay? They said that you don't get access to Trump's defense playbook, but here's why you should grant them here. Some courts have refrained from requiring notice because it would force the defendant to reveal an intended defense before trial. But here they say Trump has already broadcast to the world that he intends to rely on this defense. Okay, they are the dumbest people. Just because you say it doesn't mean you have to use it, okay? You always have options. You might use that defense. You might use another defense. You might use 100 defenses or no defenses. Just because you say it publicly doesn't mean that you're going to actually use it. And it's wild to me that the prosecutors are basically saying that they can infer this is his strategy and therefore they get access to the keys. Another court expressed concern that requiring the defendant to give pretrial notice would not place reciprocal discovery burdens on the government, another issue. Here, as explained below, Jack Smith's team writes, related non-privileged discovery already in possession of the government has already been given as part of our robust discovery productions, which are not very robust at all. as we've learned from the defense. Courts have also denied pretrial notice, meaning you don't get the playbook, because the defense was unlikely to arise. Here, though, given the nature of the charges and the defense, little doubt exists that the defense will arise in opening statements and during the questioning of the government's witnesses, and it may even affect jury selection. So just because Trump has said it publicly, they're saying, now, Judge, you have to just make him say it officially, and that way we can get an advantage as this trial moves forward. Even though other courts, other jurisdictions that are not DC don't do this, and the rules don't say anything about it, you should do it anyways. And we know where we are. We're in Chutkan's court. So they continue. All right, Your Honor, now that you know all of that, Trump has made public statements about his reliance on advice of counsel, but he's not provided formal notice to this court, a notice that would trigger discovery obligations. And they're like, we really want those discovery obligations now. But by December 18th, the defendant is required to produce any exhibits, including the ones that include advice of counsel. And to promote fairness and efficiency, by the same date, he should also be required to provide formal notice of his intent to rely on the defense and then promptly produce the required discovery. So Trump has a lot longer, okay? Trial is not scheduled in this case until March. And other circuits have said, you don't have to bring in this defense until trial, till the day of trial. And they're saying, Your Honor, we want at least 3 months, provided this trial doesn't get postponed at all, to comb through Trump's attorney-client privileged materials. They say requiring notice promotes fairness. Fairness for the DOJ. Your Honor, Judge Chutkan, fairness dictates that the government should be provided notice and discovery about the defense sufficiently before trial. As another court found, 3 other enumerated defenses, like alibi and insanity and public authority, which are other affirmative defenses, right? We don't see in there advice of counsel. There are rules for the other ones, like alibi. You got an alibi? You say I was in Hawaii when something happened and I couldn't have been there. Well, we can, show that up. So we got to have disclosures about that. Same thing with insanity. You can challenge that, right? Put them in give them psychiatric evaluations. So advice of counsel is not on the list, but they say it's close though. They say in other instances, we have gotten pretrial notice. And this really shares a basic characteristic with the others. These are fact-intensive defenses, and they're going to create substantial problems of fairness for the poor DOJ if we learn about it for the first time during trial. So they want advance notice. So given Trump's obligation to provide discovery that arises from advancing this defense, Trump should not be permitted to pepper his exhibit list with documents that support his advice of counsel defense. Do you see what they're writing? He shouldn't be allowed to just fill up our documents. And these are the same people who delivered 8 to 10 Washington monuments full of discovery to Trump. So they don't want extra paperwork. And they shouldn't allow Trump to be coy with formally noticing the defense so as to withhold discovery, undermining it, and then ambush the government with the defense during trial. You're going to represent and defend your own interest in trial, and you're not going to notify us about what you're doing? They say the defense does not have a constitutional right to withhold all defense and surprise the government. Well, that is true, right? So in some instances, you'll see situations where in the Hollywood movies, you'll see like a witness like springs through the doors at the last minute. It's like, I've got the gun, not guilty, whatever. That doesn't happen. But you would disclose a bunch of stuff. They would disclose a ton of exhibits, hundreds and hundreds of exhibits, okay? Thousands of exhibits. They've got I don't know how many millions of pages now, millions and millions of pages that go to Trump. So Trump can't pepper his witness list, his exhibit list with his own exhibits showing his defense? That's the point. And you pull him out at trial. Oh, so we're going to impeach this witness with this. And they use their exhibits as they want. Now, the government wants them to notify them about their legal defenses. So in addition to having publicly advanced the defense, they really, really don't like Trump talking, and they're trying to make him pay for it. The defendant knows what information the government has and does not have that might support or undermine this defense that he was relying on counsel. The government produced in discovery the privilege logs for each witness who withheld information on the basis of the privilege claim on behalf of Trump or his campaign. So we know who the people are. They already told us 25 of them. And in some cases, Trump's campaign was directly involved in discussions regarding privilege during the course of the investigation. In other instances, and meaning they couldn't get that info, right? They couldn't get access to it because it's privileged. In other instances, the government produced court orders requiring the production of the material that was claimed, compelling Trump to provide notice, and thereby discovery would be reciprocal of what the government has already produced. So in other words, we know what we've got. Now we need to know what you've got. They say defense counsel has already publicly identified one attorney, John Eastman, as we know, whose advice the defense intends to rely on at trial. And they're making that up. They've just said that on TV interviews. But you can say a lot of stuff on TV interviews. A TV interview is not the court of law. Prosecutors. And the government has produced in discovery substantial evidence regarding his attorney and his advice and relevant search warrant returns. So they did get access to some things. And any material relevant to the attorney's advice that remains shielded should be produced to the government at the earliest date. So we want to see the rest of Trump's attorney communications. They say, Your Honor, Judge Chutkan, in filing this motion, the government does not concede that Trump is entitled to offer an advice of counsel defense at trial. We don't think we're not legitimizing that, or that such a defense is supported by competent evidence. Indeed, if the evidence disclosed by Trump shows that the advice of counsel is unavailable as a matter of law, in fairness, the government should be permitted to raise the matter in advance of trial before questioning an argument. Juxtaposed against such a defense, the indictment alleges that Trump ignored the advice of his attorneys and was not acting in good faith. And the court may need to hold a hearing in advance of the trial to determine if he should be allowed to investigate. So, right, remember, the government, they've got a bunch of other witnesses who say that Trump was acting beneath the standard of care. Okay, he was acting maybe unreasonably or criminally, according to Jack Smith, because he was doing things that were so outside of the advice of counsel. It was so, abnormal. Now, Trump is saying, and I agree with this, that there is a different legal theory that he was relying on that was not criminal, that was much more aggressive than the other DOJ people, and he's free to take that path. Happens all the time. It happens every day. Lawyers talk to their clients every day, and they say, hey, we've got a range of options here. This is the most aggressive thing that we can do. If we go this route, we might win. We might go to trial, and you might be found not guilty, or you could be convicted, and you could go to prison. Okay. Now, on the other end, we've got this very safe option, which is we take a plea deal, you get probation, you do community service, the whole thing goes away or whatever. And you might have a lot of people, most people, in fact, 99% of people are going to take that other side. It shows up in the plea deal numbers in criminal courts. But 1% or 2%, they're going to go to trial. And Trump is absolutely the 1%er, all right? And he took it to trial. He took his case to trial in front of the American people. And then the FBI and the CIA set him up. But the whole thing is that he's allowed to pursue that. So they say that if Trump is going to make this defense, they're going to bring in the advice of the other lawyers on the SAFE team. And so Trump is going to have to bring in the advice of his other counsel. They say, finally, Your Honor, while fairness warrants pretrial notice of the advice of counsel defense in this case, fairness, this is our government prosecutor talking about fairness in Washington, D.C. on the January 6th case against a 4-time indicted political opponent of the state. Requiring it imposes no unfairness on the defense, other than the fact that their entire thesis gets disclosed to you, and you get access to all of their private communications between Trump and his lawyers. Aside from that, given his extensive public statements, Trump cannot complain that formal notice will prematurely or unfairly reveal a hidden strategy. And since Trump must produce exhibits in support of this by December 18th anyway, he must produce the exhibits, okay, in support of advice of counsel defense, but he doesn't have to label them as advice of counsel defense. You understand? Trump could just say, yeah, I'm going to call this guy and this guy and this guy and this guy and this guy. Here's my exhibits. And then do it. But they want it done now. They want it notified so that they can go crack into the emails and the other communications. They say Trump is going to suffer no prejudice, and it's not even going to hurt the defense. After all, producing and identifying an otherwise privileged document will operate as a subject matter waiver for all related communications. A lot of law here. There's no unfairness to requiring Trump to provide formal notice that then triggers the requirement of producing the discovery. So Trump files the notice, they get to go open the floodgates. And they also say, Judge, by the way, we like efficiency here. We like how you just don't let Trump even read his evidence. Requiring pretrial disclosure will also prevent disruption of the court's schedule and further judicial efficiency and allow the defendant to produce the discovery that such a defense would entail. Trump publicly claims to have multiple lawyers providing advice during the post-election period, and at least 25 witnesses withheld information based on attorney-client privilege grounds. So the process of disclosure and review, followed by the potential litigation, is going to be time-consuming, Judge, and so we've got to do it in advance of trial. Otherwise, we know Trump's going to bring it up and it's going to screw up our case. So the discovery and the investigation process surrounding this advice of counsel defense may raise additional issues prior to the trial that are going to require a bunch of briefing and additional inquiries from our side. So if Trump fails to provide timely notice and discovery, the court should preclude Trump, you see this, from even using the defense at trial. So if Trump doesn't notify us, if you say you've got to notify Trump of what you're doing by December 18th and you don't notify us, you now lose the right to do that at trial. So claim it or lose it. Use it or lose it. So they're trying to stop that as well. Pretrial notice is all the more warranted here because Trump is likely to arise and the defense is likely to arise in the opening days of trial. They say, here's what we expect. Trump may wish to discuss it even in his opening statement or on cross-examination. Trump could elicit privileged information that was previously shielded from the government, and it could sandbag the government and necessitate an interruption of testimony or an adjournment. Oh man, they don't want to get sandbagged like their boss, Joe Biden, can't even walk across a stage. That's the point, DOJ. That's the point. That's why we bring it up out of nowhere, so you don't get to know it. And the government should be shielded. Now, you're sitting here, Judge Chutkan's like, oh my gosh, we don't want the government to trip over the case in the middle of the trial, saying there is no benefit in allowing defendant Trump to wait until trial to advance his defense. There is to Trump. Rather, efficiency requires that the government receive notice and discovery in advance of presenting its case so that they can fairly prepare for direct and cross-examination and to avoid recalling witnesses either in its case in chief or in rebuttal. Now, this reads, it's like a whiny child, honestly, like complaining to the principal. And you know what? The principal's it's the principal's kid. It's like, oh, great. This kid's getting everything that they want. Notice should be given when exhibit lists are due. So they're already going to notify you about the exhibits, which again are not categorized. Or they don't have to tell you, we're going to use this exhibit for this defense. Once the decision is made to require pretrial notice, Judge, and I expect Judge Chutkan to do it, the court should set the deadline most reasonable to accomplish the twin goals of fairness and efficiency. Notice how we don't see presumption of innocence or due process or equal protection under the laws or promoting candor between attorneys and clients. No, they just don't want to get sandbagged in their own trial. And it's fair for them and it's more efficient for them. The deadline most directly related to the advice of counsel defense, most directly related, it's not an actual deadline for it, is December 18th, 2023, the date on which the parties are supposed to exchange documents anyways. By that date, Trump is already required to provide functional notice by way of exhibits, which is not true, right? You don't know. He could file 100 exhibits and you don't know where they're going, that he intends to offer into evidence. And they're saying that, that's just the trigger to get them access to the rest of his attorney's materials. It boils my blood. The court should formalize Trump's requirement to produce discovery by requiring notice at that point. Trump's intention to pursue advice of counsel has a direct bearing on the exhibits he will use. Presumably, he's going to try to rely on, for example, the, quote, very detailed memo from a constitutional expert. His counsel described in an interview, and he's going to need that in his exhibit list. He would also need to identify any exhibits to ensure that he made a full disclosure of all material facts to his attorney, and so on. And so this could come in the form of many things: text messages, attorney's notes, communications, and all of that, which would result in a waiver over the other privileged materials. So he's going to disclose those anyways. We're going to get access to those anyways, which gives us access to the other things anyways. So Judge, just let us do it now. Requiring Trump, so making the defendant give formal notice at the time he designates exhibits, is a natural complement to what we do. Parties must also submit joint instructions for voir dire and other things. And we won't be able to submit an effective joint proposal until we know what Trump's intent is, which is amazing, like that they care about that, because Trump says that we can't know what our defenses are until we read the discovery, but they don't care about that. For example, they say Trump's asserted defense may inform what questions the parties and the court may want to ask during jury selection. And the court would benefit from having this in writing, especially the part on advice of counsel. The Red Book does not contain details on what we should do about this, but in more simple cases with fewer attorneys on whose advice a defendant purportedly relied, courts have ordered pretrial disclosure in other cases. And in other cases where they didn't, those cases are distinguishable. We've got prudential reasons and saying we know that a lot of people are going to be coming in, at least 25 witnesses here. So given the potential number of attorneys and the breadth of advice that's involved in this case, Trump should provide notice about the identity of each attorney who provided advice, the specific advice that was given, including whether the advice was oral or written, the date on which the advice was given, and the information that Trump communicated or caused to be communicated as well. Do you see all of that? They say, in conclusion, the parties, the jury, and the public have an interest in an orderly and efficient trial. The court should build an appropriate interval into the pretrial schedule to ensure that we get access to everything we need from this new defense that we're claiming Trump is invoking, even though Trump has not invoked it. For that reason, the court should enter an order requiring Trump to provide his notice by December 18th, and that way they can open up the floodgates and see what's inside. Here's the proposed order saying if Trump serves notice, he must at the same time produce in discovery all communications or evidence, as well as the things he does not even intend to rely on at trial. So they submitted this over to Washington, D.C. They want Judge Chutkan to sign off on it. And I have some concerns about this. I think that she might, right? She might require him to post notice, and we'll see what he does. He might forego. Now, the question is going to be, what happens if Trump forgoes this? He says, no, we decide that we're not going to use this defense because they don't want to open that Pandora's box. Then I wonder if they're going to say that they should still get access to it anyways because he's communicating it. Then they would say that he's going to be precluded from using it at trial anyways. And so we'll see what Judge Chutkan does. I think she's got a strong inclination to give the government access to all Trump's attorney-client privileged information. We'll see if she does, and of course, continue to follow. Now, there was also another update in Florida. This is Judge Eileen Cannon. Not a big update, but we're talking about deadlines and orders, and so there was a temporary stay on the SEPA deadlines in that case as well. So that trial might be moving around a bit. We're not sure, but we do have some pretty sizable updates from Jack Smith, now trying to breach Trump's attorney-client privilege, which is a big, big thing. If that happens, that could be a big problem for the Trump defense. We'll continue to cover, my friends. Thank you for joining us as we do. Thanks for subscribing and hitting the like button wherever you're watching it, and we'll look forward to seeing you on the next one. All right, my friends, now we've got another filing, and let's see what's inside this one. Also from Jack Smith. Jack Smith now wants juror protection. This is also in the January 6th case. And we're asking ourselves, what kind of protection do January 6th jurors need? They're Washington, D.C. jurors. Do they need protection from being mugged when they're out at their cars? Or do they need protection from Donald Trump's mean truths? Well, you know where Jack Smith is taking this one. And this comes on the Judge Chutkan docket. We'll take a look at what's inside because they're changing the rules. They know they've got a very favorable court, and they're trying to modify the field so that they can win the game. And here is what they submitted. Now, this one is United States of America versus Donald Trump. This is the government's, again, opposed motion. So they've already talked to Trump about this. He says, I don't want you to go forward with this. I oppose. I object. This one from Jack Smith's office was written by Molly Gaston, the highlighter girl, the one who doesn't want Trump to read anything because she says, I organize it for you. She's writing this one. And what's interesting about how they titled these is this is their motion for fair and protective jury procedures, which, as you know, means that these will be unfair and that these will likely be protective for the government, not the process or the jurors. They write, trial in this matter in which Donald Trump, a former president, is charged with attempting to overturn the presidential election and disenfranchise millions of Americans and obstruct the peaceful transfer of power. Oh, this is definitely a Molly motion. I can feel it already. Is a matter of national importance and will likely generate significant public attention. Well, of course, that's why you guys brought the case in an election season after he's already announced that he's running, and why you scheduled trial the day before Super Tuesday. Like, that's the point, right? You want to prosecute him and criminalize him, but you don't want him to speak out in his own defense. So they say, Molly, to ensure that jury selection, voir dire, in this case proceeds in an orderly, efficient, and fair manner. And every time they say fair, you know it's unfair. What they're proposing. The government proposes that the court use a written juror questionnaire shortly in advance of in-person jury selection. A questionnaire, and we'll see if Trump agrees with this or not, a questionnaire would save time by allowing the court to excuse some potential jurors without requiring them to appear in court. By permitting the court to organize and streamline their questions, we can dispose of certain people. The questionnaire will only be given early access to prospective jurors, and we can conduct open source research regarding them. So the jurors will fill out the form, then we can investigate them. The court should impose reasonable boundaries for research And Trump opposes the motion. All right, so Trump doesn't want any part of this. So here's what they say. Your Honor, the court, you, Judge Chutkan, you have broad discretion to manage jury selection. One of the things you do is to maintain control of the process, preserve fairness, and the court's discretion includes determining whether we could use written juror questionnaires. It's one of the things that you can do. You can also do other things. You can pose questions. You can talk about anonymity of the jurors. You can sequester the jurors, and so on. In this case, Judge Chutkan, the court should exercise its discretion to streamline jury selection through the use of a questionnaire. And Trump's people say no. At the same time, in light of the public attention that is expected, and the defendant's record Trump of using public social media platforms in an intimidating manner, further evinced by the events in a separate trial in New York, okay, Trump was very vocal, the court should implement several of the standard measures frequently used, again, in this district to protect the jury and impose additional clear guidelines about the use of information about potential jurors. They continue. The use of a written questionnaire will expedite the process of picking a fair jury. When confronted with trials that last a long time, they're going to require a large jury pool. And we've used other questionnaires in other partisan hack prosecutions that you've seen in this courtroom, including against the Oath Keepers and the Proud Boys. We used them in both their cases. Here, a questionnaire in this political prosecution will also make in-person voir dire more efficient. It's going to allow the parties to confer and strike jurors. It's also going to assist the parties in creating succinct lists of questions and save time. In particular, the government proposes the following schedule consistent with the written questionnaire process directed by this court. First, the court should order the government to draft a questionnaire, get with the defense, fill out a proposed questionnaire, and then the court can finalize it. So get with the defense and draft it. Then the judge will ultimately approve it. Then we'll send it out to the jurors. Depends how long, doesn't really matter. Days, weeks, months, doesn't matter. We send it out to them, and then they'll fill it out and send it back. If the court approves this use of the questionnaire, the parties will then learn the identities of the jurors in advance of jury selection. It's commonplace in this district for the parties, once they get the juror names, to open source, use social media to do research on them. And given the sensitivities of this case, stemming from Trump's record of using social media to attack others, the court should impose certain limited restrictions on the abilities of parties to conduct research on the jurors. Oh, so they don't want Trump to go investigate the jurors. I was waiting, where was this going to go? They say that limited restrictions on the ability of Trump to conduct research on potential jurors. The court should also strictly enforce this district's rules to shield juror identities. They say it's pretty standard for people to do open source research on jurors. They look up their social media accounts and so on. And the court should make clear to the parties, though, like scold Trump, that research beyond what is publicly available, especially if it results in any kind of contact with a juror, would infringe on the juror's privacy rights. The parties should thus be precluded during jury selection from asking to follow or to friend anyone or to make any analogous affirmative request. So Trump shouldn't be able to go and be friend request you to gain access to posts or profiles or other things. This prohibition should not apply to mere passive viewing of publicly available information. So you can view stuff, but don't like it and things. And also, the party should be precluded from any form of investigation, whether online or otherwise, that could be perceived as vexatious or harassing, which they're never intending to do anyways. So this is just kind of like smearing the defense, right? It's just like throwing crap at the defense, and it's really pretty rude and gross, but it's what they do. Like on the other end of this, they might think that it's insulting. They might think that Trump is, a Hitler reincarnate or whatever, right? They are literally that demented. But the lawyers, like, why would the lawyers engage in harassing investigations or inquiries? Like, it's insulting to the lawyers. They're not going to do that, obviously. So the court should also prohibit the use of information gained from juror research from any other purpose other than jury selection. And even there, the court should require that if a party intends to use any information that they got, the party does so in a way that does not reveal any juror's identity. This limitation is consistent with local practice and so on. And they say, finally, the court should admonish the parties to handle juror questionnaires and jury sheets with care. Okay, admonish them, yeah. Hey, you guys in Jack Smith's office, you guys are constantly leaking to the media. A lot of the news comes from the Washington Post and the New York Times, including requiring each party to ensure that any individual who accesses these materials cannot publicly disclose the info. So with respect to the questionnaires, this is analogous to other restrictions that have been in place, and these precaution is not only necessary to ensure that all this information is handled appropriately, but also to ensure the court protects their identities. Now, here's where they get into Trump's statements. They say, Your Honor, Judge Chutkan, there are other good reasons in this case for the court to impose restrictions and enforce the prohibition against publicizing jurors' identities. Chief among them is Donald Trump's use of social media as a weapon of intimidation in court proceedings. Trump's posts are weapons of intimidation now. In addition to the record before the court from the government's previous filings, just last week alone, Donald Trump was in court in New York and escalated his conduct, and he publicly attacked the trial judge's law clerk in his pending civil fraud trial in New York. Trump did so by reposting on his Truth Social account. It's got 6.4 million followers, a photograph of the judge and the law clerk and a U.S. senator. He said, Senator's girlfriend is running the case against me. How disgraceful. So it was the judge Engeron. It was his clerk, and it was a picture with Chuck Schumer. And I think he deleted that post. He said this case should be dismissed immediately. As a result, the judge in that case was forced to issue an oral order that no party speaks publicly about the members of the court staff. And given that Trump, after apparently reviewing opposition research on the court staff, chose to use social media, there's a cause for concern he may do that with jurors too. So it's necessary that the court limit him on the research. Now, every time Trump posts something, they're going to try to finagle that in, right? Trump wasn't talking about jurors. Trump was talking about a clerk who was whispering in the judge's ear every time. Even before Trump's most recent concerning conduct, as the court is aware, Trump supporters had already directed threats to the court and to grand jurors who returned an indictment in Georgia. And they keep claiming that, but I don't believe it and I don't condone it. For these and related reasons, another federal court presiding over a civil case also involving Trump found it appropriate to adopt juror privacy requirements. So the court should do the same thing here to stop the jurors from intimidation and fear from Trump. And finally, jurors in this case are likely to receive substantial media. In consultation with the Marshal Service, we want jurors to get access through discreet arrangements to make it into the courthouse. That's why we request additional protective measures. In conclusion, Molly writes, to ensure an efficient process for a fair and impartial jury in this case, the court should use a written questionnaire and adopt measures to protect the identities, privacy, and security of the jurors. Now, on its face, seems like a pretty bland motion, and we'll see what Trump's response says. Now, he's obviously opposing this, and we'll see if it's in substance or if it's in procedure, what the actual objection will be. I think obviously they're framing him as though he's intending to go do those things, and he's clearly not. And I think that if they agree to the motion, like obviously Trump is not going to go harass the jurors, okay? That's obviously not going to happen. And Trump's research, right? We didn't see anything in here that's going to limit his research other than he can't use it publicly. But I think we're going to see a pretty hard written objection. I think that they would want to not use a questionnaire so that the government doesn't have the time to investigate everybody. So that you just off the cuff, like, let's just get the jurors based on a feel. And I think that that would be opposite to what the prosecutors want in this case. So it'll be curious to see what happens here. Less of a substantive motion. I'm curious to see what Trump's response looks like when we get there. But this is the Chutkan docket, and so we'll see some more activity on this case soon enough. Nothing here in the follow-up to that filing. So when Trump's team responds to this, we'll, of course, cover it, my friends. Hopefully you're joining us and subscribing and hitting the like button to join us on the next one, and we'll see you there. All right, and we've got one final segment on the day. This is a Hunter Biden segment, and a little bit shorter on this one, but this is Hunty, and man, this is another doozy. Hunter Biden is claiming immunity, and we knew this was coming, but it's not just immunity from his plea deal. It's immunity from basically everything that he's ever done, and there's a lot. We now know that there are 25,000 more emails plus that have been uncovered. Apparently, they're being stored away, tucked away at the National Archives. They don't want to disclose those documents to anybody, but America First Legal is digging into them, and we'll go through the numbers in detail. But first, this immunity situation, because Hunter, as we know, has been charged with crimes, totally joke crimes relative to the actual criminality that he's been involved in. But because of the sequence of events in this case, remember, he got charged with an information, which was basically a misdemeanor type of a deal. The plea deal was already settled. They were just going to walk in and sign some paperwork and call it a day. Well, that all went awry. Judge Norica threw the whole thing out, said, you guys are trying to pull a fast one on us. And so the government had to come back and then indict Hunter Biden. So the original information, the original charging document was kind of no longer needed, right? Because we've got an indictment now. The information is a much simpler charging document, and they were able to do that because they had a deal worked out. But now that they didn't have a deal, they needed to go establish probable cause, convene a grand jury, go through a formal indictment. So what has happened is Hunter's people are responding to the government and David Weiss. David Weiss filed a motion to dismiss the information, the original charging document, because he's supplanting it, replacing it with this new indictment. Well, Abbe Lowell, Hunter's lawyer, says, you can't do that. You can dismiss, sure, feel free, but we already have an active diversion agreement that immunizes Hunter. Pretty simple filings, but this is going to be a big can of worms that they're going to have to unpack, and the DOJ is going to respond to this. And the DOJ, in my opinion, is largely corrupt, as is David Weiss. So we'll see if he fights this. We understand what's happening. David Weiss was responsible for botching the whole plea deal. He gave Hunter an advantage in the mess, which allows him to claim immunity. Now we're expecting the same guy who created that opportunity to defend the opportunity for a favored defendant. David Weiss worked with Hunter Biden's brother, Beau. So we see here, this is what David Weiss ultimately submitted. Not a long filing, pretty simple. This is coming from Leo Wise, actually from David Weiss's office. He was the actual physical person who was there in court when the plea deal got botched. 4 pages, quick, says, hey, the government is now coming through and voluntarily dismissing the firearm information. He got 2 sets of charges, tax and firearms, without prejudice because we got an indictment. Pretty simple. Says the United States here voluntarily dismisses the info. Why? A grand jury came back. Return an indictment. We got 3 felony counts. On June 2023, The United States government, through David Weiss, we originally filed a single criminal information. It's like a speeding ticket. Hunter, like a little tiny little document. 2 crimes: illegal possession of a revolver and tax crimes. He had an initial appearance on the charge. I think it was actually 3 charges. Regardless, he had an initial appearance on September 14th, though. A grand jury came back, okay, because the plea deal got botched. So when the plea deal got botched, they did their initial appearance. They came back with the 3-count indictment. Hunter got charged formally with the 3 different charges, specifically false statements during a background check, false statement filling out paperwork, and the tax charge. They say, Your Honor, as you know, the Fifth Amendment says that you cannot be prosecuted twice for the same crime. It says prosecutions for felonies must be presented and started by a grand jury. An information was filed in this case earlier, but at that time, because we did that because we had a negotiated plea deal. But that negotiated proposed diversion agreement included a waiver of indictment, meaning if Hunter signed this, we didn't need to indict him. Or if this was accepted, is the more accurate way to say it. At the July hearing, U.S. probation declined to sign the diversion agreement. So it was not ultimately in effect because probation did not sign it, says the government. Therefore, it did not enter into effect, and therefore, as a result, no effective waiver of the indictment was valid. Footnote 3. Specifically, they say, paragraph 1 of the proposed agreement expressly said that the term of this agreement shall be 24 months beginning on the date of approval of this agreement unless there's a breach. They say here, the version of this agreement, this is the prosecutor writing, David Weiss, so-called, says the agreement that Hunter docketed has an empty signature line for Miss Bray, immediately below the approved by signature line. So Hunter cannot claim that the U.S. probation signed the diversion agreement, which was a necessary condition precedent to the formation of the agreement that he negotiated, because it did not, okay? So the government is saying this deal that immunizes Hunter, which should have never, ever been allowed in the first place, is not valid because one person didn't sign it. Oh my gosh, like, can you believe that? What if she would have signed it? Hunter is totally immune. So it's like, I can't believe she didn't sign it. I can't believe they didn't just squiggle a name on there. That's it. This is the same prosecutor's office who's now trying to fix this. Okay, the same people, the same team who botched this whole thing are now leading the prosecution. It is so rigged, I can't even explain it. Further, at the hearing, the court raised concerns about the proposed diversion agreement, whether it's enforceable or even constitutional, which was drafted by the DOJ, who are the same people in charge. I mean, shouldn't they have all been fired immediately? As a result, for trying to rig a plea deal that was unconstitutional, questioned by the judge, as a result, the court deferred the decision on the proposed diversion agreement, didn't accept it. And so thus the defendant did not waive the indictment, okay? Meaning he needed to be indicted again, so they did. So following the hearing, the court and the defendant, Hunter, engaged in negotiations to address the concerns about the proposed diversion agreement. But as the government previously told the court, the negotiations did not result in an agreement. Because the parties could not reach an agreement, the government informed Hunter in writing that it was withdrawing the most recent version of its proposed diversion agreement. They say here, in addition to the Fifth Amendment and the rules, Hunter must be charged by indictment, and it must be done in a speedy manner. And so the government did that in comportment with the speedy trial rules. That's why we brought our indictment on September 14th. We did it in time, so we're not out of time there. So they say, with all of that said, the information should be dismissed without prejudice, right? Meaning the case is still active. The information is gone. It's just been replaced by the indictment. So now we've got 3 felony charges. Now, pretty simple. Seems pretty obvious. Here's what Hunter's lawyer says, Abbe Lowell. Very simple filing claiming immunity. And they're going to stand by this. And this is what they should do. This is great legal work. And they had it set up for them by Biden's own DOJ, right? I'm less and less skeptical that, I think this was probably a mistake. Like, they would have liked the plea deal to have gone through, obviously, because that would have been absolute immunity. But this is the next best thing, is just to say that it got messed up and to have the same people who couldn't get it through the first time botch the fix, right? Have them screw up the fix. So here they say, this is Hunter's response. Defendant Robert Hunter Biden, we submit this response to the special counsel. And we say, we begin this matter by noting Hunter's disagreement with much of what the special counsel asserts in his motion. We disagree with much of what you just said. Most notably, Hunter maintains that the standalone and bilateral, two words that he pulled out from the transcripts, it's on its own and it's bilateral, meaning 2 sides. So Hunter is actually doing things. Hunter is complying by the terms of this. That both parties signed, they say it remains in force. Prosecutor signed it. Hunter signed it. We don't need probation to sign it. And he will seek to dismiss the indictment against him pursuant to the immunity provisions of that agreement. There it is. The whole thing, okay? The full indictment with all 3 charges. He's going to seek to dismiss it because of the immunity provisions. The only charge that special counsel was permitted to bring under the diversion agreement is the charge in the information. And if the special counsel no longer wishes to pursue that charge, it has the right to do that. And he knows that he can't do that now because the case has been botched. There's no deal for the information. The information was based on the deal, that Hunter would sign that deal. He's obviously not going to sign that. So, and the government is not going to bring that case because they got called out on that by Judge Norica. How dare you bring this unconstitutional, ridiculous case? Type of plea deal. And further, Hunter's position is that the enforceability of the diversion agreement has no bearing on the motion to dismiss, and any disputes about the diversion agreement are not before the court at this time. Signed by Abbe Lowell. Just amazing. So that, I think, is going to be an interesting debate. And watch us wake up and David Weiss just like, oh, sorry, I guess we screwed it up. I guess Hunter does get immunity after all because we botched it. Or did they botch it? Or is this how they wanted it to go from the very beginning? So very, very interesting stuff happening there. Now, the question is this it? Are we going to see more charges against Hunter? Because there's a lot more smoke here than we even thought. And Joe Biden has been missing in action. Now, Byron Donalds confirmed this for us. He says, Americans are being killed and held hostage by radical Islamic terrorists in Gaza. And where's Joe Biden? On Saturday, Joe began making calls 8 hours late, and he spoke for under 3 minutes, took no questions. On Sunday, he called mid-morning, a mid-morning lid, meaning he's done for the day, and then he held a barbecue. And on Monday, he called a pre-noon lid. This is basement presidency in action. Byron sharing this one, okay? Monday, October 9th, 11:52 a.m. before noon, for crying out loud. They said to the Wranglers, which is all the press people, they say, hi, everyone. The White House has called a lid for the day before the pool call time. We will not be seeing the president today. We will not be seeing the president today. Isn't that interesting? So that's pretty curious because there's a lot going on in the world right now, if you haven't noticed that. So the question is, where was the president? Well, we now know about this. He was being interviewed by the special counsel. And this was the statement that was released by the spokesman for the White House, Ian Sams. Remember that Joe Biden has his own classified documents problem, although the FBI didn't raid his house and smell Dr. Jill Biden's, gosh, I can't even finish the thought. like they did to Melania. So they instead are giving Joe all sorts of benefits. And they released this little statement. Joe Biden's been missing in action, and apparently he was being interviewed for criminal charges that will never come, even though he was not the president, did not have the power of the opinion clause, had no right to take these classified documents out of anywhere when he was a senator. The documents were at multiple locations, and Hunter Biden had direct access to them, and Hunter was working with foreign companies as an unregistered foreign agent. Slightly problematic, but the media didn't talk much about this at all. Instead, this little statement comes out, says, the president has been interviewed as part of the investigation being led by special counsel Robert Hurr. The voluntary interview was conducted at the White House over 2 days, Sunday and Monday, and concluded on Monday. Joe Biden took his break for a Sunday barbecue. As we said from the beginning, the president and the White House are cooperating with the investigation as it has been appropriate, and we have provided relevant updates publicly, being as transparent as we can, consistent with protecting and preserving the integrity of the investigation that's being run by his own DOJ. We would refer other questions to the DOJ at this time. And of course, Biden runs the DOJ, and they're covering up for him as they've been doing since, well, 2019. So very curious. Now, we know that the White House has lied a lot about this. In fact, on our members only stream this morning, we had a conversation about an article from CNN where they confirmed that too. They said, well, we kind of get lied to by them, but we like being lied to because they like to be abused by their own government for whatever reason. But there is a lot more here. America First Legal, a great follow over on the X platform, has been doing some great digging on this, and they tell us there is a lot more here. So for all of the no evidence leftoids like Dan Goldman and others who are out there saying that there's nothing to confirm the Republican suspicions, here are some numbers for them. From America First Legal at America1ST for First Legal on X, says, breaking, our Freedom of Information Act lawsuit against the National Archives has now revealed that the then Vice President Biden's office had the following emails. 19,335 with Rosemont Seneca, Hunter's business. 4,000 emails, 4,243 with Hunter Biden to the Vice President's office. 1,750 emails with the brother Jim, and 3,738 emails with Jim Biden's Lion Hall group. Now, this comes over from a status report. Sounds like America First Legal is suing the National Archives, as you can see here on this document. And this is an update to the court. Pursuant to the court's order, America First Legal and the National Archives submit this joint status report. They're suing, saying, we want access to all of these materials. The National Archives says we can't give it to you. And the judge says, well, you have to give some stuff. And so I want to know what the status is of the document disclosures. Here's what they excerpt for us. They say, through our discussions with NARA, America First Legal has requested that NARA bypass one particularly large set of records awaiting review. So the National Archives is like, wow, we're working really hard to read these documents. Trust us. We're going to read through them all, just one at a time. But we've got one guy working on it, and he's got a computer from 1994. All right, so it takes like 17 minutes for him to open up a record and confirm it. So it's going to take us about 700 years for us to get these files back to you. Okay? Is that going to work for you? No, it's not. So the America First says that NARA, can you just bypass that guy with his Pentium 4? And America First has proposed narrowing the request. So we submitted a big one, but let's narrow that down. In response to this request, they use specific search terms. NARA has found the emails, the National Archives, going to Joe Biden, 4,000 emails to and from Hunter, 19,000 emails to and from the domains at Rosemont Seneca and SenecaGA.com, 1,700 emails to and from Jim Biden, and 3,700 emails from the domain LionHallGP.com. At the current processing rate of 1,250 pages per month, it would take, that's it, okay? How many pages per month? It's just crazy. 1,250 pages per month. They want Trump to go through like 1 million a month. It would take NARA more than 15 months to complete its processing of the request. 15 months. Like right after the election, which is great, right? Definitely don't want us to see this before the election. So accordingly, on October 3rd, the AFL provided NARA with another list of search terms, and we've requested that NARA increase its monthly processing rate, okay? Get through the emails faster. And that is from America First. So, monstrous amounts of evidence. There is a lot there. Over 29,000 or so emails from Joe, his VP's office, to Biden crime family associates. And I'm very curious. I mean, maybe those are all dinner plans. Maybe they're all talking about the weather. Maybe they're all just totally innocent. And the National Archives just doesn't want to disclose them because, you know, confidentiality purposes and so on. Now, I think that as more and more evidence comes out, it's going to become clear. And the people who were denying that there was criminality here, they're going to be looking pretty foolish when we start to see what's inside. Of course, my friends, we're going to continue to cover. Thank you for joining us. Thank you for hitting that like button and hitting the subscribe button and visiting robertgovea.com to sign up for our daily newsletter. And we'll look forward to seeing you on the next one. All right, my friends. Well, that is it for us on the day. So we covered some Hunter Biden stuff. We've got juror updates out of the Jack Smith case, and they're really going hard after Donald Trump and his attorney-client privileges, and I've got some concerns about that one. So we'll see what happens. But now, my friends, it is time to hear from you and to see what you have to say about all of this and more. We're going to be going over to our members-only stream at watchingthewatchers.locals.com for our members-only after party here in a minute. And so we'd love to see you over there if you care to join us. watchingthewatchers.locals.com. And our YouTube friends, join us for the after party, but grab the Telegram link. So just on YouTube, go to the community tab on our channel, download, click the Telegram link, scroll down a little bit, you'll see it, and then join us. But who do we have in the house? We got Steph D is here, and thanks, Zach, for clipping for us. Who's in the house? We've got Steph D, and she says, missed you last week when I was on a much-needed vacation. Thanks for catching me up. Well, hey, Steph D, we took a good week to miss together, and that's good because I was traveling last week too. I was in Irving, Texas, and had a great time. So I missed you back. It's good to be back. I'm glad you're back. Hopefully you had a beautiful vacation and you're off to a great start. Sometimes you need like a couple days to recover from your vacation. So hopefully you're doing okay. That was yesterday on Monday, but we're doing good. We're back. Thanks, Steph D, and thanks for the dono. Hey, John McGarvey is over on Locals. What's up, John? John says, hello, watchers. Please stop encouraging Rob to make big, beautiful spotlight announcements this week. He has to MC a very important event this weekend. That's absolutely true. I do. It's going to be ericshouse.org 2023 fundraiser, and it's going to be fun. 4 hours of hope and healing, baby, on a Saturday. And so check out Eric's House. They have a YouTube channel also, and we'd love your support. It's going to be fun, and they always do a great job assembling everything. I just show up and drive the bus for a few hours, but it's a lot of fun. Check out Eric's House YouTube channel if you want to join us on that one. It's a lot of fun, a lot of inspirational stuff, a lot of really heartwarming stuff gets shared there, so come check it out. And thanks, John, for the plug. John inviting 5 new membos. Woo, John. So who's coming in? Johnny Boy, Marlene S., Clinton G., Patriots, We're Under Siege, and Local Admin. Uh-oh. Local Admin joint. I think they've got root access to the entire software. All right. Local admins here. All right. So thank you, John. Very generous, bringing in 5 new membos. John, you're a great membo and a great mod. We appreciate you and love you, my friend. Another one from John. 10 more. Thanks, John. From Gary Y., All the Marbles, Holly K., Pitch L., Craig V., Tree R., 3 girlies, Tom S. and Yannick J. G is in the house, courtesy of John McGarvey, bringing in 10 more members for a total of 15 from John. And thank you for that, John. Which means our members-only after party is going to be lit, and our members-only morning stream tomorrow is going to be lit. We'll look forward to seeing you guys there. Glenn Carroll also became a supporter over on the tubes. Very nice to see you, Glenn. We'll see you tomorrow morning and this evening for the after party. NY says, all right, after this is over, someone needs to go after Jack Smith's law license. Well, that, you know, he's in D.C., so he's pretty well, I think, fortified over there. Yeah, but maybe when Trump comes in, he can prosecute these people for prosecuting him. I mean, I really think that that's how it can go and probably should go. Fred is here, says, I think the burden of proof is on the prosecution. So yes, ordinarily, Fred, you're absolutely right about that. The prosecution does have the burden of proof, but when the defense is invoking an affirmative defense, they've got to offer up some proof of that. Like, you don't just get to say, so the easiest analogy is the self-defense analogy, right? Like, if you punch somebody and break their nose and you claim self-defense, well, it might be, but we need some evidence of that. Like, the government is not going to go and prove your case for you. So as a defendant, it's an offer of proof. You got to come up with something, and then that flips the burden back over to the government. So it shifts to you for a little bit to offer enough for your affirmative defense. Then it flips back over to the government to overcome your affirmative defense. And it varies by state and jurisdiction and all the things. Now, Jonathan Manson over on the YouTubes, thank you, Jonathan, says, this case is abuse of process. It interferes with President Trump's fundamental right to be a candidate. Interlocutory relief injunction should occur. It would be nice if that happened. I just have my doubts about it. You know, these interlocutory appeals, the judge has to basically certify it, and then the Court of Appeals has to certify it, and I don't see that happening. I think that they're going to run this thing through a trial. And unless the Supreme Court steps in or they sidestep them or something, but, Chutkan is going to do everything she can to keep it on the track. Now, I agree with you. I think it is a grotesque violation of many different norms, not only Trump's candidate abilities, but his free speech abilities, are the basis of the entire charge. And we talked about his immunity provision yesterday. If you haven't seen the immunity provision, certainly check that out. It is a good one. The immunity motion. We read through that yesterday. Jonathan Manson is in the house. Says, A, I didn't do the thing. B, even if I did the thing, it was legal. And C, if the thing wasn't legal, my attorneys told me it was. Yeah, that's a nice little hierarchy, generally speaking. Yeah, generally, that's a nice hierarchy. I think that what we're hearing with Trump is that, well, at least what we talked about today, it's kind of skipping the I didn't do the thing, right? That's the affirmative defense part that we skip over. Kind of saying, I did the thing, but it was legal, right? We're actually kind of skipping over A and B. Actually, B is included in there. But yeah, exactly right. And there are all these different permutations. And in some of these things, right, Trump will say, I didn't do the thing that you're saying I did. Like, maybe I did the act, but that act is not contributory towards insurrection, which, of course, they didn't charge. But good to see you, Stephen. Thanks for the very nice dono today. Hope you're having a beautiful week, my friend, and I appreciate you being here. MAGA Hat Stays is in the house. Says, can we, the public, waive the right to a speedy trial? No, unfortunately. The public is just an amorphous blob out there that we all just get lumped into. And we're a general concept. We can't actually get together and vote on it, but it's a nice theory. I think it's an interesting one. Ryan Patrick's in the house, says, smash that like button, baby. Thank you, Ryan, for saying that, my friend. And thanks for being here and jumping in the chat. And you should smash that like button, no matter where you're tuning in from. Just Cause is in the house. Says, shout out to Ryan Patrick in the chat. Ryan Patrick in the chat, man. Shout out to Ryan Patrick in the chat from Just Cause. And Ryan Patrick over on YouTube. And so make sure your support, and Ryan Patrick as well. And Just Cause is in the house, sending some love. Thanks, Ryan, for stopping by, my friend. MAGA Hat Stay says, I would like to waive the right to a speedy trial. Can we file a class action motion with the court? I don't think so. I don't think that that's going to go anywhere, unfortunately. I mean, you could file a class action if you want. It'd be interesting, or it'd be an interesting read. But no, the public can't do that. They're going to think of the public as just the general concept. You know, in general, we want speedy trials. In general, we want efficient courts. In general, yeah, we want fair rules. But fairness is a different concept when you're in DC than maybe when you're in Florida, or as we saw in Tennessee or other places around this great country. We got this one from Nevada Legion. It says, great job, Robert. Thank you, Nevada Legion. Very nice dono in the house. Very generous. Says, you have the best legal informative show ever. Thank you, Nevada Legion. And I think I tend to agree with you. I think it's pretty dang good. But I think it's really good because of you and your support and all the great comments we get, and because of the work that we do here together in the community we're building. And so thank you, really, very generous. And thanks for watching over on Rumble. And shout out to our Rumble friends. Rumble's doing a lot of cool stuff. We got dance masters over there, users over there, indoctrination, Brad's over there. I see Dog Diggers over there. Androdite is there. Chat's popping off over there, man. We're almost at 1,000 people watching, so very cool. And so thank you, Nevada. Good to see you. C. John also bringing in some gifts. We got C. John bringing in Luke, Nikki P., Ricky S., and BJ Marshall, and Will Call Magic, all coming in courtesy of our member, C. John, bringing in 5 new members. Thank you, C. John, for doing that. We love our new membos, and we try to deliver for our membos. We try to really do a lot of extra content for our members because we appreciate you guys. We got here, this one is from B. Torn. Says, this case and the others is the railroading of Trump with a mile-long train traveling under the Atlantic Ocean, loaded full of cement trucks, stacked on top of boxcars of lead, going 1 mile per hour. Man, that is a very poetic sentence right there. I got visuals. Did you guys get visuals? It is. That's what it feels like. It's like slow motion, gigantic, just pile of garbage coming under the Atlantic. It does feel like that, B-Torn. Very, very colorful language. It's very poetic. I appreciate it. Grifty has been here. What's up, Grifty? Been a member for 3 months, 1/3 of the way to a baby. Says, can SCOTUS intercede with any of this on their own? Yes. So the answer is always to that question, yes. SCOTUS can do whatever they want. They're SCOTUS. So they can, they've got jurisdiction over basically everything. Now, will they? Probably not. Will Trump, appeal some other way or try to go directly to the Supreme Court? Could a judge presiding over the circuits, do something about it? Certainly. But I think it's unlikely. They can, but it's very unlikely. And so thank you, Grifty, for being a member. 1/3 of the way to a baby. We're glad that you're joining us. Randy's over here on Locals. What's up, Randy B? Says, how can Hunter admit under oath to a judge the crimes he committed? Does that not count against him? Great job as always, Rob. So it like yes and no. I think if you're asking about the context of the plea deal, and in that context, like what he said in the plea deal is not going to be used against him because that's in the course of a settlement. Generally, the things that you're doing in the course of settling your case, like the negotiations and stuff, those are not held against you because they're in the interest of settling the case. So, for example, if your defense attorney sends a letter, often called a deviation request, to the government, and there were a ton of letters sent here between Hunter's lawyers and the government, what they admit in that letter, like they might say, yeah, Hunter did this and Hunter did this, but he did this and this and this, and he's, rehab and blah, blah. Like all of that is like off limits because it's in contemplation of the plea deal and in the settlement. And if we penalize people for having those conversations, we would never have any cases settled. So we just kind of leave all that out. So the judge is not going to like get him in a gotcha moment and to say, oh, busted, right? You admitted what you've done here. It's all just kind of part of the process. She might know it, right? She read through the thing and, he wanted immunity from all this, but he never got it. And so she like understands it. But nobody's going to charge him for that. Like, he's not going to be penalized for that because the DOJ was encouraging that. Like, they were partners in that whole conversation. So it's a great question. And, my next question, the next question is, what's the DOJ going to do with this? Like, they know that there are more crimes. They know that all this stuff has come out in public now. Are they going to try to cover up with the same thing that they were doing, or are they going to have to change the game a little bit and actually be more honest about what they're doing? It's looking like they're going down the latter path, not because of their own, not on their own volition, but because they're being forced to do it by the revelations. We had this one from Coletti on YouTube. What's up, Coletti? Became a member and a $1 dono from Coletti, but no question on there. And thank you, Coletti. I do appreciate that one. No even sticker, just a dono. Thank you, Coletti. I appreciate it. Jameson says, my blood pressure. Yeah, no doubt. Today was kind of a troubling read of a day, but we'll have Trump's responses to those, and so those will be much better and much more interesting, no doubt. And Jameson says, I wonder what is process for complaints on Jack. You mean like submitting an ethical complaint or like a bar complaint against the guy? Yeah, I don't think they're going to go anywhere, honestly. I don't know where he's barred or what the formal mechanism would be for that, but he's probably got a bunch of them and they'll probably just throw it right in the garbage. He'll probably be promoted to like ambassador or something. So thank you for that, Jameson. Good to see you. And this one came in from MAGA Hat Stays and sharing this image of Trump during a better, more peaceful time in our country. Certainly, indeed. All right. And that one is coming in over from MAGA Hat Stays. And of course, let's take a look at the X and see what's going on over there and see is Elon joining us today? Somebody needs to tell Elon to join our live streams. We could use a boost from Elon from time to time. Let's see. Is he watching us right now? No, probably not. Says there's only 3 people watching. Well, probably not Elon there then. Sometimes we hit double digits, but not today. So we've got some comments on the X. Danny's here. Says, in DC, Trump case is an abomination of the law, no doubt. Fred says, and do you think judges in higher courts are reading these indictments? Yes, I do. I think a lot of people are reading these, probably watching the show, hopefully, and listening to them. I can't see SCOTUS allowing most of this BS. The justice system will be changed forever. Couple from Danny McWilliams, including a vomiting Lady Liberty, if you'd like to see that. D. Jones says, where are Hillary's emails? Oh, she destroyed them. Like with a cloth? Wonder what she gave our enemies. We certainly remember Benghazi. Yeah, and Darkside Digital's in the house. Says, fairly prepare. They had 3 years to prepare, and they're dumping 11 million documents on Trump and expecting him to be prepared in a few months. The gall of Jack Smith. And Troublemaker Jonah says that Jack Smith is the reason that the USA has to invade the Hague Act. The International Criminal Court is the kangaroo court in The Hague. And so good comments from our friends over on X. I see, hey, what's up? Black conservatives in the house. Says from New York City MAGA guy. Says getting my daily watch in. Look at this one. Hey, this is funny. All right. So this is on Twitter. What's up? Hey, what's up? Hey, what's up? Maybe see ourselves on the screen. We'll see you later. From Black Conservatives, NYC MAGA guy over on the X. Good to see you, Black Conservatives. And hey, Old Drill Sergeant says, thanks for a great stream. And Cohen's here and says, I wish that Mr. Govt could well, thank you for calling me Mr. Govt. Thank you for that. Says, explain to his audience the process of selecting the Speaker of the House. Do the Republicans vote first or do they have the majority? We do not want Hakeem to be the Speaker. That's for sure. So it's a good question. I don't know what the Republicans are even doing. I think they're meeting right now, as a matter of fact, to figure it out. And so I think they may have increased the rules to 217 or something. I don't know what the official number is. But yeah, I mean, the Republicans technically have the majority. The question is going to be whether they can cobble together a majority for any one person, right? That's the real question. and we don't know if they'll get there. Steve Scalise or Jim Jordan, we just haven't been able to really get a grasp on what it looks like. Now here, this one came in from MAGA Hat Stays, and this looks like it is a chart from election betting odds, and they've got DeSantis, looks like he's dropped down onto 4th. Wow. After Vivek. That's from election betting odds. And yeah, so we like to check that website on our members only streams in the morning. And Jameson said, there are laws, LOL. Who knows? Research, I wonder? There are laws, yeah. Well, there used to be a lot more meaningful laws than there are now. Now there's, I think, the current structure of our government, at least from the Biden people, is like they're just kind of suggestions. You know, the Constitution is really just kind of a nice afterthought, but not for us. But my friends, those were all the great donos and the amazing support. Welcome to our new members. We're super grateful to have you. And I appreciate everybody supporting the work that we do here. We are going to wrap it up and head on over to watchingthewatchers.locals.com for our members only after party, which we're going to hang out for a little bit longer and chat the night away. And so come and join us, watchingthewatchers.locals.com. Also, check out our website, robertgovea.com. And you can sign up for our daily newsletter, get the show reports, get everything delivered to your inbox. So if you miss something, if you don't want to go to YouTube, and if your notifications aren't working or whatever, sign up, robertgovea.com, daily newsletter delivered to your inbox. All the show reports will go there. And if anything happens here, you know, I can make sure we stay in touch that way. Also, thanks for supporting Eric's House, our 2023 fundraiser, watchersupport.com, or there's a link in the chat that you can click on and go and make a dono, and we're very grateful for your support, and we're going to spend some time going through all the extra love that comes in near the end of the week here. And so thank you for supporting us, watchersupport.com and Eric's House. Also want to say thanks to the mods who mod down the fort for us and keep things nice and orderly. Our friends Vienticus Prime, K-Bean in the house, Just Cause, we've got Playin' Hooky, Ronnie Cole, our friend Zulu, we got Beyond Geo, Zach Nichols, John Allen, Janek 909, Dog Digger, Donut Mind Me, and of course, John McGarvey in the house. Also want to shout out Geegum Geegum, Nathan N810, and our friend Sleepy Dog Lee over on the Twitter. And we want to say thank you to everybody who helps assemble and keep things nice and beautiful here. Very grateful for our mods and our incredible chat. We got the best in the whole world. But that, my friends, is it for us on the day. We are going to leave it there. We're going to head on over to watchingthewatchers.locals.com. And I have something a little bit interesting that we'll try today. A little bit of a transition video. See if it works. Let me know if it plays music. But we're done. We're going to go over to watchingthewatchers.locals.com. We hope to see you there, but if not, we're still going to be back here tomorrow to do it all again, and there's going to be a lot to attend to, and so we hope to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.